So let's continue with a few more of the legal issues. I want to talk about SEC compliance, drill down on some of these exemptions, talk about U.S. versus offshore offerings, Investment Company Act, exchanges, compliance, and some of the marketing issues. So let's first talk about Reg CF crowdfunding. I'm seeing lots and lots of these deals being offered, whether ICO or STO, as Reg CF deals. And that's the exemption that came in with the Jobs Act in 2012, where you can sell up to a little more than $1 million worth of securities in a 12-month period. And you can sell to anybody, accredited, unaccredited. We just have to meet these net worth and annual income requirements. Sounds great, doesn't it? There is a downside. It's expensive and burdensome. Number one, the investment has to be through a platform, which typically means a broker-dealer or a funding portal. You can't just go out and advertise these to the public. Number two, there's lots of limitations on these. Sometimes requiring audited statements, definitely requiring a filing, requiring a business plan. The issuer has to make sure the investors don't exceed the caps. We have to have all sorts of acknowledgments. And most importantly, you're selling small amounts to a large number of investors. In a legal world, investors are also known as potential plaintiffs. So there's some cost and risk associated with a crowdfunding campaign. Here's a description of some of the filings that have to be made. You can download the slides if you'd like to review this in more detail, but it is relatively expensive. Expect to spend 6% of your offering on a crowdfunding compliance, legal brokers, all in, etc. Second sort of offering, and this is what we do way more often than any of the others. And a private offering, this is under Regulation D. And there's two types, really. There's 506B and 506C. 506B is what we usually use. And this is an offering to accredited investors only who may self-verify that they're accredited. Well, what do we mean by accredited? That means annual income of $200,000, current year and prior 2 years, or $300,000 jointly. Or they meet a net worth requirement. That's $1 million in net worth, excluding personal residence. So this is accredited. If we do this, we have to have a pre-existing substantive relationship with the person that we're soliciting, with the offeree. If we don't have that, then we drift over into a 506C offering, which is an offer through solicitation or advertising, and this means anything. Facebook ads, skywriting, going through the phone book, and you can do a sale of securities that you publicly solicit now, provided that all the purchasers are accredited under the definition I just read to you, and the issuer takes reasonable steps to verify the purchaser's accredited investor status. And that reasonable steps is the part that hangs people up. There are third-party services now that will do this for you, but otherwise you're going to have to verify that they're accredited. Almost all of the token offerings we do are under this exemption, 506C, just by the nature of digital assets. They are going to be advertised and solicited widely. We want that network effect, remember, so we're almost always going to rely on 506C. So general solicitation, here's an example of what reasonable steps are to verify. You can review these steps at your leisure. They're in the regulations, but you do need to see third-party documents or hear it from a third-party confirmation agency such as a CPA, a lawyer, or an investment advisor. Reg A. Let's talk a little bit about Reg A. Reg A is an exemption that's been around for a long time and rarely used because it was a low maximum offering. It did not preempt state law, and it was very expensive. Well, the Jobs Act came along and improved it. We gave us new and improved Reg A. We call it Reg A Plus. And Reg A Plus allows an issuer to raise up to $50 million and preempts state law registration. Note, we still have notice filing requirements, but preempts registration, but we have high federal compliance burdens. It's like a mini public offering. And a Reg A Plus deal, you can see that there are requirements, investor maximums, investor limitations, but they do not have to be accredited. So a Reg A Plus issuer does not have to verify or even sell to only accredited individuals. What they do have to do, however, is make disclosures, financial statements, offering circuit audited financials to the SEC, and basically get permission from the SEC. I will tell you a lot of people have attempted to sell tokens under Reg A+, but they're finding that that is a very long process because now you've got regulatory oversight. And in token land, time kills deals. Reg S, this is a safe harbor that we use oftentimes in conjunction with Reg D. This is where we sell securities in another country. In other words, we target only foreigners, and we put protections into our documents to make sure that only foreigners are going to buy the security and only foreigners will buy it in a resale. Before we leave that, I will say that there are different flavors of Reg S as well, and they have to do with the resale restrictions. If there's enough U.S. content in the Reg S deal, the securities are going to be locked up and not able to be resold in a resale, which is what everybody wants when they buy them. It's one of the reasons people go offshore, so they're not U.S. restricted at all, so they can sell under a different exemption under Reg S that doesn't have a resale restriction. The ICO, very complicated, and here's a good example. Issuer number, step one, typically they would sell a SAFT, that's a simple agreement for a future token, do a pre-sale to an investor. They would take back cash, fiat, cryptocurrency. Step two, they'd use those proceeds to build a platform. Step three, they do the ICO. For technical legal reasons, they probably cannot do a public offering of that security. So when we say ICO, we don't really mean that. What we probably mean is a Reg D, Reg S offering of the tokens to investors, and then those SAFs that the early investors in the pre-sale got in step one will convert into tokens in the step three ICO. Numerous considerations in this sort of offering and requires a big team. So number one, on the securities compliance side, I think we've gone through that. We'll typically use 506 credited only for our U.S. investors. We use Reg S, foreign targeted for our foreign investors. And then there are other exemptions that we could use, but they're not really very practical, and people haven't been successfully able to use them. On a resale, we have Rule 144, 12-month holding. Section 12G and Rule 12G3 have to do with the exchanges that are allowed to resell the securities.